At this time, I'll call upon the state for its rebuttal close.
May it please the court.
Yes.
Counsel. Ladies and gentlemen of the jury, I am going to show you the last photograph taken of Charles McCormick. I am showing you this photograph because that's what this trial is all about. It is about seeking justice for those brutally murdered. I show you this picture not to inflame your passions and make it so you find somebody guilty. I do it to specifically rebut a comment of defense counsel. Before we go into that offensive comment, I want to say this.
Objection to integration of counsel.
Overruled.
What I am commenting about the defense, I wholeheartedly believe in the Sixth Amendment of the United States Constitution and Mr. Robinson's right to have all the witnesses against him cross-examined by a zealous advocate, and that is what we did. My criticism is not that they have tried to do their job. My criticism is that the defense stood up here after the young black man investigated by a black detective and tried to imply that this case is somehow about race. And somehow country singers or hard rockers don't get investigated. Only young black men who do rap songs do. And that's not true. Detective Smith poured out his life into this case for hundreds and hundreds of hours. And he didn't do it because of the race of the victim, and he didn't do it because of the race of the defendant. He did it because Lady Justice is blind. This courtroom doesn't consider those things. This courtroom says that that bias cannot come into your decision-making. Judge Salvador will tell you as such. This is about whether or not the state has proven its charge beyond the exclusion of every reasonable doubt. And we embrace that. It is not about young black men that rap and somehow us taking it out. Charles McCormick. You're going to hear a common theme throughout my rebuttal argument. Hakeem Robinson is either the unluckiest man who has ever lived on the face of the earth, or he's just plain guilty. The vast majority of the defense closing argument about how an incredibly lucky piece of evidence, the dash cam video, somehow implicates that we have the wrong guy. That's been their defense since day one. Countless parts of his closing argument are about that. January 4th, January 14th, January 15th. It's not just about hairstyle underneath the hood. He screams over and over and over again, 6'3", 230. And then we have the photographs that show it's just not true. It's just not true. We have digital laser scans that say it's 6'125". One of the reasons I'm showing you the two different views from Defense Exhibit 3 is to show how the light looks. Is 3-2-30? Because you have Hakeem Robinson. Months before, a couple days after, wearing identical. I see what it is. The evidence proves that's the same sweatsuit. You can tell just from that picture? No. But it's a pretty dang good piece of evidence. In the video, Atlas, dash cams, surveillance videos, DNA. I've been doing this long enough that I remember when we didn't have all those things. And it's made our job a heck of a lot easier. And more importantly, it's made your job a heck of a lot easier. Because artful defense attorneys pounding their fist on tables, which they should do, their client. All of that doesn't change, and the picture can tell us 1,000 words. In this case, it tells us one. You're talking about slender, these poor witnesses. Okay, challenge number 1 from the defense. Get up here and explain why you didn't call witnesses that were working out in Bailey's and looking through glass. He said, what did he say? He said there's clean and dirty windows. Was Mr. Williams looking through a clean Bally's window or a dirty Bally's window when he was half a football field away with a guy crouching down? That his testimony to you doesn't help you make this decision because we have a video. The descriptions are totally irrelevant in this case. And then, they stand up here and argue. How dare we pay $70,000 to $90,000 for a paid extra? We're just buying our conviction. You know who deserved that? Hakeem Robinson deserved the state of Florida to spend tens of thousands of dollars to figure out if all these descriptions, and mind you, they're not all. People that are closest put it right on more better descriptions. And when you look at the photographs of him at the time, he's much smaller than he is now. But regardless, we wanted to invest that money. The defense attorney gets up here and glares about how concerned he is with the government. Know that your government spent your money to make sure that all the corroborative evidence was right. That we could exclude Barner and Whitaker from that video. By the way, they match the description that everyone gives. We're going to put so much stock into these. They match it. And we invested that money to see. He's never going to be, no expert's going to be able to look at those and say they identify a particular human being. Does the body morphology. He says there's no way these two guys that match the description of the shooter given by people who admittedly don't know. And I'm guessing someone crouching after they watch a shooting for 2 seconds. He's not. He deserved that money. He deserved every penny of it. He gave that to you so you can have confidence. All the other evidence in the case. Oh, little something, something. Talk about it's actually, it's been a long time. Cross-examining the medical examiner. Arguing about 5'9", 5'11". The doctor, in his report, his measurement, says that the victim, Charles McCormick, by the way, that's his address where all their cell phones are made. It's fine. Driver's license says it, medical officer says it, and the video shows that the shooter was bigger, wider, and taller. I wouldn't call it an insignificant amount, which perfectly matches the way Hakeem Robinson looked the day before, weeks before. Remember, this is the defendant next to Leroy Whitaker. You've had the opportunity to see them. Not a huge difference, is there? And we know that Leroy Whitaker is smaller than the victim. 40 minutes or so, we heard about it. The video proves our case. Now, of course, no one's asking you to look at that video and find the defendant guilty beyond a reasonable doubt. Because we're giving you so much more. A couple rules that Mr. Robinson or any aspiring young rapper should live by. If you're gonna brag or post about killing somebody, you probably shouldn't have DNA in the murder car or a fingerprint on a gun left behind in the murder car. If you're gonna post hoodie pictures of yourself singing and rapping in the weeks and months before and after, you probably shouldn't wear the black and tan hoodie to commit the murder. If you're gonna have a burner phone, you probably shouldn't take selfies on it. If you're gonna stake out a victim, you probably shouldn't get distracted and let him leave his apartment complex, so you have to follow him to a Merrill Road strip center where police officers are hanging out. And if you're gonna pick co-defendants to do the case with, you probably should have done it alone. If you're gonna get picked up by the girlfriend of one of your buddies, you probably should hope that she's ride or die, that she's not gonna come to this court with no intimidation, with no cases hanging over her at the time she gave her sworn statement and here today, and say, that's who I picked up. And just for a second, before you think, well, maybe Hakeem Robinson, he's too smart to do that. Whoever did this killing, it includes Whitaker and Barnett, they decided to go in broad daylight in a neighborhood, jump out and run through a strip mall and execute a human being for the whole world to see. The actions of a 21-year-old that gets excited and angry because he sees the person that has so disrespected his brother. Has dared utter these words.
Smoking on wet leaf, Parker screaming up for help. Hand shot instantly. Yeah.
Put it in your blood. Shoot, we be smoking on with it. Picture to the left, rest in peace, brother, is posted less than 24 hours after the defendant took care of the person that spoke on Willie. There are very few people in the world, not exclusively this defendant, we've arrested a lot of them. A lot of them are charged, not all. A lot of them are charged. And there are others out there, but there aren't that many in ATK that had a motive to kill 6-block little Buck. The greatest motive was Abdul Jr. and Hakeem. remind you, we tried these two cases together. All the evidence against Whitaker corroborates what Varner says, what the entire investigation leads to, and all of that evidence helps prove Robinson did. That's why we tried them together. So while you're not deciding Whitaker's case, you're going to have to know some of that evidence to know why Hakeem Robinson is guilty. And some of that is the phone records. But we have the opportunity by both defendants. Varner's admitted it. The opportunity by both defendants. Either the cell site is off or it puts them there. The defendant, by the defense's own admission, his known cell phone. Known cell phone. Now, 21 years old. Want to get the times right. He has his cell phone powered off for the exact amount of time it takes to do this case, to do this crime. When his cousin and friend, overwhelming evidence, also overwhelming on him, when they're doing this crime, it just happens to be powered off. And the defense, I submit to you, was trying to show that the data on the phone, because you see there it's data, and this is the situation where the FBI analyst was unwilling to map the data sessions. Between those two times, nothing going on while his phone's turned up. Remember the cross-examination of the expert over and over again? He was on a boat. He was, no, your smartphone is on. It's getting data. Even if it's not connecting to a tower, it'll show data usage. So they kind of followed that. But when we plotted the data usage, which the FBI was unwilling to do on their own because of the errors, 95% accurate, I think 95 to 98% accurate. You know what that data usage, so this is when we did the Google Maps stuff and we put in the coordinates. When we did that, his known phone, his admitted phone, was in two really important places before it got powered down. Remember those Google Earth pictures? It was one picking up Varner off of University, Spring Park. You saw that map. Then it was off Atlantic Boulevard, which is exactly what Dominic Varner said they went to pick up the Impala. Excuse me, the Nissan, to commit this crime in an apartment complex off Atlantic Boulevard. His phone, known phone, is in those two locations, just like Varner said. And those were never mapped. Varner couldn't have been fed the information by the state. Throw in the hole, just like he said, like Varner said. So the other phone records show that you can see the red is going to be Mr. Robinson's burner phone, the phone that he takes selfies on, that Hakeem Robinson got in his dead friend's name that he handed him, that existed for about 2 months. On this particular occasion, Mr. Robinson thought that burner phone would never be tied to him because his real phone was turned off. And by the way, the whole selfie thing, and he never said, dads don't call their sons on their burner phones. Dads call their sons on their real phones. The burner phone is when you do dirt. So, he's hitting off the Merrill Road Tower shortly before the crime. The arrow points that he is going in the vicinity of Townsend Boulevard. This is you see the arrows, the red arrows, and then the 7201 Arlington, and the defendant's burner phone is going in those directions, and you can see the data usage in the green box to the right of all the little arrows. He is going in the direction of where he is picked up. This is his burner phone. His real phone is turned off. And then we find that it's going in the right direction. We find the cache. He deleted all this, by the way, but this was found in the cache. He didn't know about that. Off the pin drop in the location of the nature preserve. You kind of see it cut off, the nature preserve, the tree hill on the right side. That is just, I don't know, maybe 100 yards, Lillian Road, Lone Star. That's just a little bit north of where he was picked up by Natalie Gann. Not the exact location, it's just a little bit north. And then we have the path he came through the tree hill. On nature preserve, where we're not at Boston, identified a person in a black and tan sweatsuit. Just the unluckiest man on the face of the earth. Or is he just identifies a black and tan sweatsuit coming out of the woods. I think he's a nature lover. And then Natalie Gann picks him up. Says a white girl carrying a phone. Mention the IP address. The defense makes a big deal about Smith not being an expert because the IP address helps prove that the burner phone is Hakeem Robinson's burner phone because of the IP address. The T-Mobile records, some of which you'll have in there, if you care to look at it, actually in some of the instructions, not all, but in some of the instructions in the records, the top line says the IP address, only the first four numbers should be considered. It's not, the records that we have introduced in this case tell you it's just the first four numbers. It's not just Smith. That's just a side note. So we have them all together, meaning back safe on Brown Jersey Court, Hakeem, Kareem, and Barner, and Whitaker. Look at that. And this is, magically, the defendant's real phone turns back on when they're safe. Objective known truths. We know the Nissan is the murder car. We know the shooter fled with the murder weapon. It's described perfectly. There is no murder weapon in the car. The murderer fled with the murder weapon. We know this as an absolute fact. Robinson is linked to the murder car in 3 different ways. The shirt, the driver's compartment swab, and the print on the firearm. Here's where the defendant, mind you, they spent 2 minutes talking about the DNA because it's not good for their case. I get it. But here's where their argument about transfer fails. Look at the way that shirt is. It's rolled up. Think back to what the DNA analyst said. I took swabs at the wearer, the neck, and the underarm. Not just in the middle of the shirt that's balled up in between the seat. And somehow, their argument is that this balled up shirt, wrapped up shirt that has wearer DNA of the defendant, oh, by the way, and we wore of the defendant, somehow that jumped off of the shirt and got in the driver's compartment and was balled up in the corner of the seat. Maybe he's the unluckiest person on the face of the earth. Maybe he's just guilty. Oh, and there's prints on the slide of the firearm. It's right next to the shirt that has his new on his DNA. Maybe you shouldn't be bragging about killing Willie with that evidence. I mean, killing Willie's killer. And bragged about killing Willie. Incredibly powerful evidence. No chance that could be tampered with. Remember, they sealed the vehicle. It's the way it was when all 3 of them jumped out because they decided to commit a murder right in front of the police. And we were able to catch them. Whitaker's in the car 2 ways. He's on both shirts. We have those shirts. Robinson possessed a similar and unique firearm before the crime. This was kind of just glossed over. But we did pay a lot of money. And in addition to this defendant deserving that, digital expert Latham provided another service. Firearm in this defendant's hand just a few weeks before this murder. And he is celebrating it on the Bang It Up music video. Is the same type of firearm. And according to Barner's testimony, is the same one. We hear from the FDLE firearms expert, right? This is the first FDLE person we called. The manufacturer of that firearm discontinued. And although there are other models like it, there aren't that many of them. This isn't a Glock 9mm or a Glock. This is some common firearm that everyone in the world has. This is a relatively, I don't want to oversell it, I'm sure there's guns out there. This is a relatively unique firearm.
Objection, Your Honor, mischaracterization of the testimony.
Overruled.
You rely upon what the expert in this Amherst said. No longer manufacture that kind of gun. Companies go out of business. It's usually because you don't sell a lot of the gun. Sell a lot of the gun, you usually keep making them. Right? AR-15 is real popular. Keep selling them. Okay. Enough on that. Barner and Whitaker were so desperate to get away that they assaulted Miss Buckley and left their DNA on her pajamas. Again, it shows that they were all in for a penny, in for a pound. And that proof corroborates Barner, corroborates Blue, who picked up these two guys after they assaulted Miss Buckley. And you heard all that testimony. With the buttons here and not here. Whitaker and Barner got picked up by Blue. We know that that's a fact. And pled. These are objective truths. You don't need to assess credibility. Robinson is right-handed. Fact. Shooter was, guess what? Right-handed. Does that prove he did it? No, but it's a nice fact to know, isn't it? He has worn a black and gray hoodie just like the shooter has worn. When you combine all of these things, you are narrowing the scope beyond just the exclusion of every reason. We are not eliminating every conceivable possibility. We are not eliminating all of them. I submit to you we have. But the proof here is beyond to the exclusion of every logical, well-founded, reasonable doubt that any logical person could have about whether we got the right guy. Robinson was real happy about the defense wants you to think that he's arrested because of this post. Sergeant Smith has his fingerprint on a pistol in the driver's seat console, like in between the seat and the console. Water. His print on the slide.
Okay.
It's in between the seat and the console. He has his print. And that's the post he sees. It's context. You know, they said, we're going to explain the context of all that. That's the context. Context is, Smith goes, holy cow, the guy's bragging about it. The kind of person that would brag about this is the same person that would go out, narrow road, 1058, and gun down another human being in front of everyone in the world and the dash cam to see. Same type of person. The video proves the descriptions were wrong. It proves it. We called the witnesses that were able to provide meaningful testimony, not the witnesses that were working out on the elliptical and looking through glass. for them to say, I guessed, and none of them were sure, I guessed about the person, and the video proves me wrong. Spent a little bit of time talking about Barner. He is a murderer. I don't like him. Defense has a good time. He got beat up twice by two very seasoned, experienced defense lawyers. It's hard to sit there and listen to them beat him up. Fine. We expected that because he deserves it. The reprehensible deal that they turned around and screamed at the state of Florida for was we got a convicted murderer to subject himself willingly his own free will to have Judge Salvador sentence him to life without the possibility of parole. And the only benefit that we gave him is you get to testify, show your remorse, stare at the face of your community, your friend, and do what's right for Charles McCormick. If you do that, the judge can consider it and do anything she wants, including giving your life. For 50 or 45 years. And he knows that. And there's nothing he can do about it. I wish all prosecutors were that unsuccessful in convicting murderers. Lou is looking at 20 years. And he's a middle-aged, 50-something-year-old guy, 55 I think he is, with diabetes and kidney failure. Not very different from the deal worked out for Barner. All witnesses meet. It is entirely proper for witnesses to meet with us. The defense wants to say, well, I'm not going to argue they shouldn't meet with their witnesses, but they shouldn't meet with their witnesses unrecorded. Scenario: Dominique Barner, you're going to plead guilty and subject yourself to life. The lawyer is here. We need to make sure this is something you really want to do, because once you give this sworn statement, there's no going back, because you're going to be under oath. We're going to sit down and make sure that this is something that you're going to be willing to do before we go on the record. Because you're staring at your friends, your community, your family, and you're turning into the one thing that you swore you would never do. Snitch. Are you sure you want to do this? Yeah? Is this what you're going to testify to? Yeah? All right, we're on the record and we're putting you under oath. Oh, how dare the government do this? A pre-meeting is somehow evil? This is what they're arguing. No witness should be discredited for talking to a lawyer about his or her testimony. Barner wants the absolute best deal for himself. No doubt about that. He said it over and over again. So his plan, according to the defense, is to lie to the people who will recommend a sentence to the judge and lie in front of the judge that's going to sentence him. What if, over years and years, we find out that he's lying to us about the facts of the case? Remember the DNA evidence didn't come back? It was until mid-2022? All that cell phone, all that Instagram, that stuff's just pouring in. And we're going through it up until shortly before trial we're pouring through. And somehow he's going to make the decision, I'm going to subject myself to life, knowing she can give me life, knowing the state will make a recommendation. I'm going to lie to these people about who's with me? The defense challenged me to say, why on earth did they say that part of the deal was I had to implicate my son from my good friend. And they said, yeah, if I say it's somebody else, the deal's not there. Because it's the truth. And if they say somebody else besides the person that did it, then of course there's no deal. Because they're committing perjury. Evidence doesn't show anybody else. The one little piece of evidence that shows somebody else, sort of, is this Chris guy whose hair, not skin cells or blood or anything like that, whose hair, which is much more easily transferable, and he lived and hung out with the people living in that brown Jersey courthouse. I don't know if he lived there, but he certainly was there. The testimony from Hakeem Robinson was he was there all the time, and his baby mama lived there. But he was there all the time, and that little piece of hair was there. So what did the detective do? Pull his cell phone records. Let's see where this guy is, even though there's no implication he's an ATK or any of that stuff, or has any motive to do any of this. But they go pull it, and he's across town. You know, one of the jurors said in jury selection, trust but verify. And that is exactly what you have seen here today. You don't have to trust every word Dominique Barner says unless you verify it. Even the defense had to admit. If you caught me smirking, it was when I heard this. The defense had to admit that Barner got his facts straight. Yeah, he did. He did get his facts straight. Trust but verify. Barner had no idea the person he said he picked him up was going to testify and agree to that. He didn't know that. He gave a sworn statement. How was he supposed to know that? Barner doesn't know that Natalie Gatton and Nada Boston were here to testify. I need to reset here because the video evidence that we had in our first slide, it shows how the defendant looked leading up to this crime, combined with him wearing the sweatsuit and then the picture of the shooter. That piece of evidence, combined with Renata Boston and Natalie Gatton, you don't need DNA, you don't need Barner. That evidence in and of itself is enough to convince any reasonable jury that we got it right. So when you combine all the pieces of evidence, we have a guy in a black and tan hoodie murdering Charles McCormick, running into the murder car, jumping out of the murder car with the same gun, running and jumping fences. And by the way, thanks for the video when you toggle. I'm not going to talk about that much more. I appreciate it. We did it. We did it. So it certainly seems like the police officer is a little bit taller than he should be. Anyway, jumping fences, doing all those things. One more thing about sprinting. You see the video. We played a little bit of it. And God bless police officers who chase after gunfire. They have to put on a bulletproof vest to go to work. But he was coming out of Publix off duty. The whole body cam thing. He's not prepared to work that day. He's off duty. He didn't
Objection,
have the body
mischaracterization
cam.
of the testimony, he was on duty.
Overruled.
That's besides. Well, you remember, it's not mine. It doesn't really matter. That he was so cautious when he was looking for me to walk by that car. Then he sprinted by the car. Officer Collins walked kind of slowly, looking around because he knows, and he said it, someone could be sitting there ready to ambush him. He saw that guy with a rifle. He wasn't chasing after him full bore. That's idiotic. That's how he got away. Renata Boston says, after I get a text alert, it takes a long time to get where the defendant got all the way through that woods and get rid of the burner phone and the rifle. Get rid of those things. He comes out of the woods wearing a hoodie by himself. And she goes, I'm getting out of here. And I did notice a girl, a white girl with a phone. Let's be very, very clear about this. Natalie Gatton came in and gave her sworn statement. She was a free woman, and everyone she loved and cared about. her husband getting arrested subsequently is irrelevant. Because she'd already given her sworn statement. These are not people, as the defense characterizes, coming in chains by the state's leash. And all the eyelash comments the defense can make about her doesn't change the fact that she was a rock on that witness stand. She said, I used to date tour guide. I know all these guys. They weren't going to go up there and pick this guy up. They told me, the white girl, you're going to pick up this guy. I don't know if you pick up. And if we're trying to strong arm her to testify, why doesn't she say he was wearing a black and tan hoodie? As opposed to the truth, which is, I don't remember what he was wearing. It was Hakeem. And that's what Not a Boston combination with Natalie Gant is proof beyond a reasonable doubt. I think the identity of the person that executed Charles McCormick. Forget the DNA, forget the prints, forget the brand, forget Barnum, forget Blue. Combine it all. That's where you get beyond a reasonable doubt. You have that abiding conviction of guilt. You can be confident in your word, and that's where we get beyond all possible doubt. Dominic Barner may be a liar. He's not lying. He couldn't know the digital expert Latham was going to analyze the body morphology and conclude the defendant could be the person behind the mask. How did he know that? No idea. And by the way, you have to combine that with the knowledge that Dominic Barner has given his life over Judge Salvador in the state of Florida as the defense capacity. He's giving his life over to us. He better be right when he tells us he did this. Because the body morphology will prove it. He's lying. He won. Barner had no idea that we would be able to link Whitaker's phone on Instagram. Instagram for Whitaker is the verification number on his Instagram records. And when he on Instagram says, this is my phone number, ding, 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 we were able to link it to Whitaker. They don't, it's not registered to him, but he says, this is my number on Instagram. And it proves, that phone proves the location every single step of the way that Whitaker is at with Barner. Step in for a penny, in for a pound. And Barner had no idea that the cloud would capture proof of Robinson's burner phone was his, and they could link him to the murder. He had no idea of he couldn't fabricate DNA and print evidence. He did not know that Robinson's known cell phone was turned off during the murder, the thumbnail and data of the known phone would be hitting off his apartment and the pickup for the Nissan. Well, how does he know that? Look at how street smart you are. It's going to be hard for y'all. It was hard for us. Mr. Cooper and Mr. Atkinson are much better at it than I am. I struggle with this stuff. And Dominic Barner's going to do it? It just means he's telling the truth. That's all it means. The defense challenged the state on a number of different things, and each and every one of those we easily rebutted. Renata Boston never said shoulder length dreads. She said dreads to the chin, which if it's sticking out of a hoodie, that's about where it is. Defense argues things like, I'm not saying that Chris Brown did it. Look at the video, you'll see the defendant's hand. You'll see Hakeem Robinson's hand and compare that to his complexion. It's the same. Not to mention all the autographs. There's no DNA transfer. The defendant was in that car, jumped over the center console, which is where his touch DNA came from, and the shirts and the guns that he'd already handled, and jumped out and was so excited that he didn't wait for his backup. 700 billion to 1 chance that someone other than the defendant is on that shirt, 4.4 million to 1 chance that this defendant's touch DNA is on the driver's area. He's either the unluckiest man on the face of the earth, or he's just plain. No matter how many times you pound on the table, scream 6'3", 230, we have the video evidence to prove that's just not true. And then, once you know you have that abiding conviction of guilt, the job is yours to find the truth in this case. The dead, they can't call out for justice. It's up to us, the living, to seek it on their behalf. Nothing that we do here can change the lives of that poor family. He will be dead forever, and the last known photograph of him will be on the slab in the medical examiner's office. But what your verdict can do is forever define who did this. It is inescapable. Ksoo Robinson is the man behind the mask. It's been proven to you 700 to We trust that you'll uphold your duty and find this defendant